Hello, and welcome to the Ministry of Government Relations four-part webinar series on development appeals. This series provides important information on development appeal processes and procedures. This video is part one of the series, which outlines the legislative framework for development appeals and how to establish a development appeals board in your municipality. Unless otherwise specified, the term Development Appeals Board refers to both local and district boards for the purposes of this webinar series. The content of this webinar series is based on the Development Appeals Board guide on Saskatchewan.ca. This guide includes several samples, checklists, and flowcharts to help make the development appeals process as simple as possible. To access the guide, search Development Appeals Board Guide on Saskatchewan.ca. For those who may not deal with the development appeals process regularly, it can feel like an overwhelming legal procedure. This webinar series has been created to help guide those involved in the process through the legislative requirements and functions. This first webinar will walk through the legislative framework that establishes authority for development appeals boards, the requirement for a development appeals board and the general purpose, the responsibilities of council for establishing a board, how to select board members and who may not be eligible, how to select a chairperson and their responsibilities, board member responsibilities, and finally, secretary responsibilities. The Planning and Development Act 2007 authorizes municipalities to undertake land use planning in Saskatchewan through the creation of planning bylaws. For the purposes of this webinar series, any reference to the Act means the Planning and Development Act 2007. All planning-related matters must be dealt with using tools provided in the Act. Part 11 of the Act outlines the requirements and procedures specific to development appeals. Most of the information contained in this webinar series comes from the requirements of Part 11. The Statements of Provincial Interest Regulations are one of the three regulations created using the authority of the Act. The statements are especially important when discussing development appeals, since all planning decisions, including those of appeal boards, must be consistent with the statements. The Statements of Provincial Interest Regulations contain 16 key policy areas in which the province and municipalities share an interest. They include objective-based statements to help guide planning decisions in those areas. The term planning documents refers to district plans, official community plans, and zoning bylaws. If a municipality has adopted a district plan to function as its official community plan, or has a basic planning statement from before 2007, that plan is considered to be an official community plan for the purposes of applying the Act. An official community plan is a statutory plan which contains a long-term vision and goals for a community in the form of policy statements. All decisions of a development appeals board must be consistent with the official community plan. The zoning bylaw is the primary tool for implementing the official community plan. It organizes land uses and development to meet broader community objectives. Let's examine zoning bylaws in more detail. The purpose of a zoning bylaw is to organize the use of land for the health, safety, and general welfare of the entire community. Historically, this has meant separating incompatible land uses, such as high-polluting industries, from where people lived. Over time, zoning has evolved to become more complex than just the separation of land uses, with the intent to go beyond health and safety to create amenities and a high quality of life for the inhabitants of a community. A zoning bylaw organizes development by dividing a municipality into zones using the map attached to the bylaw. Each zoning district has a list of permitted land uses that can be established in the zone. There may also be a list of discretionary land uses that may be established in those areas with council approval. Any land use not listed as permitted or discretionary is considered prohibited in that zone. Each zoning district may prescribe development standards for either the entire zone or for each land use individually. For example, building setbacks from property lines or maximum height. A local development appeals board will primarily hear appeals related to zoning development standards. The board is a quasi-judicial board appointed by the council and must contain a minimum of 3 members. It is an administrative tribunal that provides the public with a forum to review planning decisions. The board operates under the principles of administrative law, duty of fairness, and rules of evidence. The primary responsibilities of a board are to ensure that proper procedures were and are followed in decision-making, and that discretionary municipal planning powers are exercised fairly and based on legally adopted planning policy and zoning controls. Administrative law is an area of public law dealing with the relationship between government and its citizens. The purpose of administrative law is to ensure that the activities of government are administered in a fair and reasonable manner. Based on that purpose, government action must be legal. Officials must have effective remedies when citizens are affected by unlawful acts of government. Boards, such as a development appeals board, are designed to protect the rights of citizens when incorrect or unlawful acts of government are made that affect development, and to provide flexibility to achieve fairness in unique cases. The duty of fairness is a legal concept that describes a set of minimum requirements that the board must observe in a hearing. The board must ensure that there is no perception of bias in its conduct. It must hear and decide appeals independent of other municipal issues. At a minimum, acting fairly in a hearing means 1. Providing adequate notice of a hearing. We will discuss the notice procedures of the board in Part 2 of this webinar series. 2. Providing an opportunity for all interests to be heard. Both parties must be given equal opportunity to state their case. Also, any person claiming to be affected by the appeal is allowed to attend and make a presentation. 3. Acting fairly also means providing an opportunity for each party to ask questions of the other. Later on in the series, we will go through the hearing process, during which each party is provided this opportunity. 4. Decision makers are unbiased and act in good faith. Board members must not show any favoritism to one particular party. Acting in good faith means to act honestly and communicate openly with both parties so as not to hide any issues or information. 5. Acting fairly means making decisions based on relevant facts, evidence, and extenuating circumstances. Again, we will discuss a little later on what is considered to be relevant information and what can be discarded as irrelevant. 6. Decisions must only be made by those who heard all of the evidence and arguments. In other words, the decision must only be made by those who were present at the hearing. It is necessary for each board member to have personal knowledge of all evidence presented at the hearing in order to participate and vote on the decision. Participation in the decision-making process by an absentee board member will invalidate the decision. 7. Decisions of a board involve interpreting the issues, facts, and law presented during the hearing. The board must provide a written explanation for making its decisions, and providing reasons for those decisions ensures that the board is accountable to the public and ensures the fairness of the hearing process. The third and final guiding principle is rules of evidence. Rules of evidence were developed in part to ensure fairness. The more you stray from basic principles of evidence, the more likely you will run into issues of fairness. Evidence is the information used by parties to prove or disprove a case. The purpose is to be fair to both parties without allowing irrelevant facts to make their way into the hearing. Evidence should be adequate to support the appeal, relevant to the grounds of the appeal, reliable, admissible, and not subject to any rules of exclusion. When we discuss the presentation of evidence, we will discuss in more depth how to tell if evidence is reliable or if it is not reliable. But for now, just know that evidence according to the rules should be adequate, relevant, reliable, and admissible. With that being said, it should be noted that the Municipal Board Act states that the Provincial Saskatchewan Municipal Board is not bound by the technical rules of legal evidence. While the Planning and Development Act does not explicitly state the same for a Development Appeals Board, it may be inferred that the same holds true for a lower board hearing similar matters. As well, Macaulay and Sprague's Practice and Procedure before Administrative Tribunals, which is largely based on case law and is recognized in Canada as a leading authority on administrative law, supports the notion that technical rules of evidence do not apply and should not apply to tribunals because of the very nature of the lay tribunal being that it is not expected to have legal expertise. A lay tribunal is also expected to be a cheaper, more efficient substitute for a court of law. Therefore, wrangling over the admissibility of evidence at a hearing detracts from the real issues to be determined, and the tribunal needs a wide latitude to allow all relevant points to be put to it for expeditious review. The Municipal Council will establish a board by appointing members through resolution. Council must appoint a minimum of 3 members to the board. Since the municipality sets the bylaw standards and makes the original development decision, whether it be approval or refusal, there are certain people who are not eligible to be members of the board. Council members, municipal employees, or members or employees of a planning commission are not eligible to be members of the Development Appeals Board. It's also important to consider potential conflict of interest situations when selecting board members. For example, a consultant working for the municipality in a different capacity may not be a good choice for the board due to a perceived conflict of interest. However, the Act allows a District Development Appeals Board to include a combination of councillors from member municipalities, as long as one municipality's members do not form the majority. For example, if there are 3 municipalities in a planning district, each municipality may be allowed to have a council member on the District Development Appeals Board. The District Board would then hear appeals for development within the jurisdiction of the planning district. Ideally, members of the board will have some experience related to land use development or community planning. These might include former municipal administrators or councillors, architects, engineers, developers, surveyors, or community planners. Although members are often appointed for their knowledge and expertise in various planning and development roles, other individuals who do not possess related technical expertise should also be considered, as they often bring valuable perspectives. The screen shows some characteristics that should be considered when selecting board members. Generally, members should be knowledgeable of their role and willing to dedicate their time to the process. Although the Act allows Council to determine compensation for board members, for the most part, they are volunteers. In addition to appointing members to the board, Council is also responsible for setting the length of time that each member will be on the board, determining the manner for filling vacancies, establishing the remuneration and expenses of the board. For example, some communities provide between $25 to $75 to each member for each meeting they attend, and appointing a secretary, including setting the terms, remuneration, and duties of the secretary. Council may also authorize the board to hire consultants to assist with responsibilities. It's important to remember that the Council is responsible for budgeting for any expenses of the board. Here are some suggestions for setting the board terms and filling vacancies. 2 or 3 years is a common term length for board members. It's recommended that Council define the number of times that a member can be reappointed to the board. If possible, stagger the terms of each member to reduce the board turning over at the same time, thereby losing existing knowledge. Vacancies are often filled by application. If a municipality is having difficulty finding volunteers for the board, they may create a district development appeals board with their neighboring communities or hire a board through a consulting company. The chairperson must be elected by other board members at the first meeting. The chair should have knowledge of the relevant provisions of the Act, regulations, municipal planning bylaws, and processes and procedures. They should also have the skills necessary to control proceedings and manage any difficult participants who may be present at the hearings. The chairperson is responsible for providing leadership and attending to all matters necessary for the board's operation. They must also ensure that other members receive the proper training and follow the board directives and appropriate rules of conduct. The chairperson leads the board hearings and meetings and administers any necessary oaths or affirmations. The other board members can assist the chairperson by paying close attention to the parties' interactions, keeping track of information and hearing documents, asking questions of all parties, and having a general knowledge of the process and relevant considerations. Development Appeals Board members are responsible for 1. Determining whether the board has jurisdiction to hear the appeal. This involves making sure that the appellant is appealing one of the eligible zoning or subdivision matters outlined in the Act. 2. Reviewing the hearing documents prior to the hearing and making sure that they understand the basic elements of the appeal ahead of time. 3. Determining what has to be proven before the hearing. This involves having a good understanding of the board's considerations when making a decision and being able to set the bar that an appellant must meet to be granted their appeal. 4. Declare any conflict of interest and not hear cases where the member has a vested or perceived interest in the appealed decision. The board secretary is responsible for all administrative and operational matters of the board. It's important for the secretary to be independent of the municipality's development officer or planning department. It is also important that the secretary not be a member of the board or any other decision maker who may unintentionally influence the appeals process. The secretary should have a good knowledge of the relevant provisions of the Act, regulations, official community plan, and zoning bylaw. For the hearing, the secretary is responsible for receiving the appeal application, fees, and related materials to be properly filed with the board. Once all hearing materials have been received from the parties involved, the secretary ensures they are available for public inspection prior to the hearing. The secretary prepares the board packages with all necessary documentation and sends out public notices to property owners and other affected parties in accordance with the Act. Public notice requirements are discussed in more detail in Part 2 of this webinar series. At the hearing, the Secretary confirms that the board has quorum to hear the appeal. Quorum refers to the majority of the total appointed board members. For example, if a board has 5 appointed members, having quorum would mean having at least 3 of those members present. During the hearing, the Secretary is primarily the note-taker. As a note-taker, the Secretary should take attendance and note absences, record the names of any speakers or representatives of all parties, document any exhibits used as evidence, take detailed minutes during the hearing, and record any decisions or motions of the board. Once the hearing has concluded, the Secretary's primary responsibilities are to assist in writing the decision and ensure that the chairperson signs it. Within 10 days of the date on which the decision is made, the Secretary will send out the notice of a decision to the appellant, the municipality, the Director of Community Planning, and all persons who made representations at the hearing. If the board's decision is further appealed to the Saskatchewan Municipal Board, the Secretary will also send a certified copy of the local board's records to the Saskatchewan Municipal Board within 10 days of receiving the notice. This concludes our first webinar in the Development Appeals series. To learn more about the development appeals process, view our other videos in this series. If you have any questions related to the development appeals process, please contact the Community Planning Branch for assistance. The branch also offers in-person development appeals workshops that explore this content in more detail. Please contact the branch to arrange for a workshop in your area. Thanks for watching.